One legal move could have saved him $10 million. He didn't make it. And in less than a year, 3 decades of work, investments, and planning were gone. So in this video, I'll show you exactly what happened, why it happened, and how to make sure it never happens to you. I'm the business guy, the CEO of the Lawyers Limited law firm and Asset Protection Planners. I've been in the asset protection field for 34 years, setting up Cook Islands trusts for nearly 30. We've set up more of them than anyone else in the world. And after watching hundreds of legal battles play out, I can tell you, timing isn't just important in asset protection, it's everything. If you want your own custom plan, head on over to assetprotectionplanners.com. You get a whole lot of free information there. Let's call him John. John was a commercial real estate developer, sharp guy, great instincts, multi-million-dollar portfolio. He'd been through minor lawsuits before, nothing he couldn't settle. Then came the massive construction defect case. A tenant claimed structural flaws in a new building had caused millions in damage. Now, the claim was exaggerated, but that didn't matter. The attorneys lined up, the legal fees skyrocketed, and then suddenly, John was staring down a $12 million lawsuit. But here's the critical part. He contacted us within just a few weeks of the judgment being filed against him. Not a year earlier, not when the skies were clear, but after the storm had already hit land. So that timing meant that we had to work under the shadow of fraudulent transfer laws. So every move would be challenged in court. Every document would be picked apart, and his opponents knew it. So we told him up front, for those assets already frozen by the lawsuit, it was too late for them. So we still implemented our gold standard structure, a Cook Islands trust with a Cook Islands LLC inside of it. So why did we do that? John was about ready to receive a $2 million inheritance from his mother that the courts didn't know about yet. So we moved the liquid assets from the inheritance offshore into the structure. But here's the difference. Because the judgment had already been filed, every transfer into the trust was done under the microscope of litigation. In the Cook Islands, it's not always a deal breaker, but U.S. courts can still make life difficult. So the judge issued injunctions, opposing counsel filed motions to reverse the transfers. So we fought hard and we were able to protect the inheritance part of the portfolio, but the timing limited how much we could shield. You see, his opponents had already filed lis pendens against all of his property mid-lawsuit. So in the end, the judgment still claimed over $10 million in properties, cash, and equity because that part of his holdings was already frozen before he even called us. As we told him, if he had come to us a year earlier, before any lawsuit was filed, the outcome would be very different. Now, let me give you the flip side. We'll call her Lisa. Lisa was a tech entrepreneur who just sold her company for 8 figures. Now, she had heard about lawsuits ruining people's retirements and didn't want to be a statistic. So before she made any major investment, she came to us. We set up a Cook Islands trust with a Cook Islands LLC inside of it. We opened a bank account in the Cook Islands LLC's name, and we made her the manager and positioned her brokerage accounts and cash accounts inside the LLC. So 2 years later, a former business partner tried to sue her, claiming that she'd cut him out of the deal. Her U.S. attorneys were served with discovery requests for her assets. Our offshore structure meant that on paper and in legal reality, she didn't have direct ability to hand them over. So the plaintiff's attorney would have had to file an entirely new case in the Cook Islands, which we've never seen anybody win. They didn't. So the case settled for pennies on the dollar, and Lisa kept every asset intact. So what's the difference between Lisa and John? It's not just timing. It's also jurisdictional power. So let's unpack that. Here's why offshore protection works when domestic doesn't. U.S. court orders have no automatic force in the Cook Islands, Belize, or Nevis. And if somebody wants to reach assets there, they must hire local counsel in that jurisdiction, start a brand new lawsuit under their local laws, prove their case under much tougher legal standards, often beyond a reasonable doubt in certain claims, pay all of their own legal fees, win or lose, and this alone deters 99% of plaintiffs. For the remaining 1%, the process can take years and cost more than potential recovery. So now compare that to keeping your assets in a domestic LLC or trust. One U.S. court order and you're done. The judge compels you or your U.S. trustee to hand over the assets. What do you think that trustee is going to do? Hand over his own assets or yours? You know the answer. So timing matters once you're sued in the U.S. Every transfer you make is suspect, and if you're already offshore when the claim hits, the game changes in your favor instantly. So let's go back to John because he moved assets around to family members instead of setting up an asset protection plan after the lawsuit was filed. The opposing counsel argued those moves were fraudulent transfers. Now, fraudulent transfer doesn't mean you intended to defraud someone in the normal sense that we're used to hearing about. It's simply a legal term for moving assets out of reach of creditors after you know you might have a claim. So in the US, the look-back period for these transfers can be years. So his opponents were able to freeze those assets. Even in some offshore jurisdictions, there is a statute of limitations. Belize notably has none, but not every asset or client is best served there. So when you move assets before any claim exists, those transfers are generally untouchable. Move them after, and you're in for a fight. Okay, why people wait and why it's dangerous. I've seen this play out over and over. People delay setting up protection because they think it'll never happen to me. They're waiting for a big liquidity event. They believe insurance will cover everything. But here's the reality. Lawsuits happen to good people. Money moves faster than courts, and insurance companies are in the business of minimizing payouts, not writing blank checks. So if you act early, you're setting up a legal moat that's already filled and guarded when the attackers show up. So if you wait until they're at the gate, you might not have time to close the drawbridge. So let's talk about the structure that saves fortunes. The structure could have saved John and did save Lisa. Is simple in concept, but powerful in execution. Cook Islands Trust as the owner, Cook Islands LLC inside the trust as the asset holding entity, and you as the LLC manager during calm times. Our licensed bonded trustee law firm stepping in only when a legal threat appears. So this means you live your life as normal, pay bills, make your investments, travel, enjoy your assets. But when a storm hits, control shifts offshore, and U.S. courts lose jurisdiction. So John's story isn't just about losing money. It's about losing peace of mind as well. He told me later the hardest part wasn't writing the checks. It was waking up every morning knowing the outcome could have been different if he had acted earlier. Lisa, on the other hand, sends us Christmas cards from her villa every year. Same legal system, same country, same types of assets, but a completely different result because she acted before the problem existed. The $10 million mistake isn't about making the wrong move. It's about not making the move at all until it's too late. So if you want to make sure that your hard-earned work, investments, and lifestyle survive whatever legal storm may come, feel free to go to assetprotectionplanners.com, fill out a free consultation form, because the right time to protect your assets is before you need to.